Brothers has come out strongly against the bail application of 5 suspects accused of the murders. The family of Amos and Zenzele Coka is still reeling from the April 9th incident. 4 farmers and a farm worker allegedly shot and killed the 2 at the Papunskral farm in Mpumalanga. The accused have pleaded not guilty. Let's take you there live.
Thank you, Council. You may rest.
When you go to foreseeability and the causal link,
yes,
would we? That is the whole principle on this, on this common purpose.
You may rest, Council. Thank you. Thank you.
You should briefly reply. If I could just finish what my learner, you asked him. He read from a land statement, but he read selectively again. After he read it, including safety and security issues, it states, and to assist the authorities to combat crime in the areas. That's what it is in paragraph 15. Further, it has to be emphasized that crime is rife and a very serious concern in the area. That's the purpose of the WhatsApp group, not to do anything unlawful. The question that your worship asked my learned friend, but is there anything unlawful about that? Clearly there's not. The evidence of the warrant officer was that he considered that he couldn't dispute the fact that there were policemen also on this group. But I don't want to re-argue the case, Your Worship. I just want to read the full aspect from the Milan statement that Your Worship can take note of.
Thank you. And you may proceed, Mr. Zwane. You may proceed.
Pagpunsola nga ko ke la pamilya kantolo ke advocate umeleke mga local and mga laws bill ay akuveza ke namhlanje la enkantolo icala leli ke bokusolo kukhulunywa ngalo la kwakuthathwa khona ke isinqumo phambilini okuyiqala ke likanzo achaza ukuthi ke icala ke likanzo la bathathwa khona ke isinqumo ngabahluleli phambilini neqala ke likaMuzwembi uthi uma ngabe wabheka lawo macala lawo indlela okubekwe ngayo noma ke inqumo ezathathwa kulamacala zehlukile ngoba kwasetshenziswa umthetho lo wakudala ungakafika isikhathi ke kwakusetshenziswa umthetho lo wakudala inkululeko ke ingakafiki ngaleyo ndlela leyo ke uthi yo advocate ke inkantolo beyiqinisile uma ithi ke ayikwazi ukuthi ingathatha isinqumo ngokusebenzisa umthetho lo usebenzisa kudala kungakafika isikhathi ke lesi samanje senkululeko kanti ke ngakwelinye ihlangothi umhlushisi ke uthi ke kuyandlulela lapho uma ngabe ke besho njalo advocate besho njalo noma advocate babamangalelwa besho njalo kufuneka ufunde ulehlele enzansi kuleli icala ke lapho likasifatha noma okanye ke umgedezi kuthiwa ke kulelo cala lelo uma ngabe ubheka la lecala esikilo namhlanje kune group ye-WhatsApp kuleyo group leyo uma ngabe ke efunda kuyi-statement zabamangalelwa ke ezibhaliwe esifungelwe kubhala ukuthi ke leyo group leyo leyo WhatsApp yila khona ke bavama ukuthi baxhumane ngayo bazisane uma ngabe ke bafuna ukuthi ke kunokuthile okwenzekayo emaplazini bathi sebenza njengokuphepha ngaleyo ndlela uthi uma ngabe ke athumela le WhatsApp message noma lo mlayezo umalani kulabo abanye abalimi abampisholo ukuthi mabeze bazosiza wayesho ukuthini ngamanye amazwi uthokona ukuthi wayethi ke mabeze beze ke bahlome beze ngayo yonke indlela ukuthi abazokuthola la bayakhona bayamelana nakho ngaleyo ndlela leyo uthi yebo ikhona icala lapho lenzeka icala ke elokubulala uyacela ukuthi inkantolo ke naleso siqeshana leso somthetho isibheke.
Thank you. The court would then remark as follows, that is now proceeding to the judgment. The court appreciates the cooperation of counsel and everyone involved and or who assisted in the proceedings.
Inkantolo ke iyagqulisa ukuthi ke bonke abo-advocate nawo wonke umuntu oyeke wabandakanyeka kulesicelo lesibheli ke iyagquliseka ukuthi ke bantu ke bayiphatha kahle
The court would remark that the bail application is a process that deals with specific issues only and does not deal with the whole or the actual trial. Therefore, there is no talk of punishment at this stage, and as the functions of the court hearing the bail application ends with the hearing of the bail application only, courts are said to have a greater obligation to society to jealously guide or guard the rule of law. Any notion or narrative that there is a particular category of persons that should not get bail is unfortunate and is untrue, as is also not covered for in the Constitution and in the law. And the court then is then bound to work or follow what is the Constitution and the law. The Constitution and the law is clear on that aspect, that everyone, it says every accused person has the right to be released on bail. The courts are also required to consider that where required, even when the counsel, the representatives of the state and that of the applicants do not raise the issue of bail, the courts then are then called upon to inquire on this if the counsel for the parties do not then, or for the applicants do not raise this. This then indicates that notion that, if any, that there is a particular sector that should not or be granted bail or should not have their bail application being heard, that one is not true.
Inkantolo ke ezama ukuchazela ukuthi ke la inkantolo ekwenzayo namhlanje noma lokho besikwenza ensukwini ephambili ukulalela isicelo sebail bokubulwa icala, kanti le nkantolo le ayinawo amandla ukuthi ke ikhiphe ke isigwebo noma isijeziso kule cala leli okwamanje. Okwayo bokulalela nje isicelo sebail. Ngokomthetho sisekelo uthi umthetho sisekelo wonke umuntu unelungelo lokuthi angadedelwa ngebail. Awusho kumthetho sisekelo uthi kune qenjana lelithile elingeke lidedelwe ngeke kumele lingadedelwa ngebail elinye lidedelwe ngebail. Cha, umthetho sisekelo awusho njalo. Ngaleyo ndlela leyo ke uma ngabe kukhona emkhondweni omphakathi ukuthi kunabantu abathile okungamele badedelwe ngebail, lokho akusikona iqiniso, ngoba umthetho sisekelo ukubeka kucaca ukuthi wonke umuntu unelungelo lokuthi adedelwe ngebail. Noma ngabe abameli bakababangalelo abakuvezanga abayikhuluma indaba yebail, inkantolo yona ngikwayo inelungelo lokuthi ke ingakuveza lokho, ingakubuza lokho mayelana nebail,
that the person may apply for bail.
ukuze ke ukuthi lowo muntu loyo angaba nalungelo lokuthi ke afake isicelo sebail.
And for the court to then consider and evaluate whether to grant or not to grant the bail based on the facts that are before it.
Bese kuba inkantolo ke ebhekayo ukuthi loyo muntu loyo ingamdedela ngebail noma ingamdedela ngokubheka amaphuzu asuka bekiwe phambi kwenkantolo ngaleso sikhathi.
The court gets to know what happened and then have to then evaluate such facts, and then after evaluating the facts before it, the court will then be required and is required in terms of the law to then exercise its judicial function.
Kantolo ke ithola amaphuzu aphambi kwayo, bawulethi ibheka amaphuzu aphambi kwayo nomfakazi obusule buthuliwe, bese ke iyabheka ukuthi ke ngabe kunaso na isisindo, bese ke ibheka ke ngoba ithatha isinqumo ngokubheka ke lawo maphuzu asubanikeziwe inkantolo ngaleso sikhathi.
And everyone, including that is departments and also sectors of society, as well as that will be meaning every department of government, they are then required that they must assist in ensuring that there is independency of the judiciary.
Kanti ke zonke inhlaka ezikhona funeke ke zenze isiqiniseko ukuthi ke inkantolo yona imele ayiqhuma ndaba.
And then the courts are required to then rely on that is public interest. And where there is a collision between public interest and public opinion, the courts are then having to go with public interest. What is in the interest of justice? What is interest of the people will then be what is the interest of justice.
Kantolo ke mangabe ke kunozinye idingo ke ifuna umphakathi noma ke imbono evela emphakathini hlangana inkantolo kufanele ibheke ukuthi ke ngokubulungiswa ke uthini ke mhlawumbe uma ngabe kufanele kwenza ubulungiswa ikuphi ke okumele ukuthi ke inkantolo ikubheke.
Looking at the length of the proceedings and the number of documents that were then handed in to assist the court felt that it really would not be in a position to proceed with an extempore judgment, but will have to proceed then with a written judgment, and has done it and will proceed as follows.
Kantolo ke ithi ngokubheka ke ubufakazi namaphepha alethiwe phambi kwenkantolo njengobufakazi ibone ke uthi ke ibhale phansi isinqumo sayo kulesicelo ke sebail.
And the judgment goes as follows, starting with the first point, being point 1 of introduction, and going further. The 5 applicants appear before the court applying to be released on bail in a case where they face 2 counts of murder, attempted murder, kidnapping, and obstructing the course of justice. They are represented by various counsel, that is by various defense counsel, and the state is represented by counsel as appears on today's record of proceedings and on earlier proceedings. There was no agreement amongst the parties as to the schedule of the offenses that are faced by the applicants, with the state arguing that the charges are falling within the ambit of Schedule 6, and the applicants' counsel arguing that it could be Schedule 5, even though they have prepared their affidavit to cover for Schedule 6 in the event the court rules that the charges fall within the ambit of Schedule 6. This, after the court ruled, it will give a determination on that aspect at a later stage. Applicants each proceeded by use of or relying on affidavits to move their application, and after close of applicants' cases, the state led the testimony of one state witness, being Warrant Officer Nhlapo, being the investigating officer in this case, whose testimony relied, amongst others, statements of people or witnesses who were at the scene. The evidence of the applicants can be summarized as follows. The court is not saying that this is the whole evidence, but then that is the summary of the evidence. The applicants each proceeded by affidavit outlining the aspects they relied on and wanted the court to consider in support of their application, and such were handed into court as Exhibit A to E and are attached to the record of proceedings. Their circumstances are briefly that applicants are local farmers or work in the farming enterprise or environment, except for accused number 5, who is employed in one of the farms. The evidence of the state can be summarized as follows, without the court saying that this is the whole evidence of the state. The state led the evidence of the investigating officer who attended the scene at a later stage, and he relied on statements of witnesses. His testimony revealed that on the day in question, a number of about 7 unarmed and peaceful African males went to a farm named Pampun Krol to meet one farmer who was their employer at some stage to discuss work-related matters, and that at some stage, after having left the farm, they were chased by some farmers, who caught one of them, being Mr. Hlatswayo. Mr. Hlatswayo, also referred to as Mlaba, whom they severely assaulted and tied with cable ties. Further, that the others who were in company of Mr. Hlatswayo phoned others or relatives for assistance to help Mr. Hlatswayo. Deceased one arrived driving by in a motor vehicle towards his residence that is along a scene later for purposes of proceedings marked as Gate B, and was stopped by those in company of Mr. Hlatswayo to go and assist him. Further, that farmers and African farm workers, including second deceased, who was in a buggy driven by accused number 2, arrived at the scene, identified later on for purposes of proceedings in court as Gate A, and deceased one arrived driving a smaller car followed by a buggy with 3 occupants. That deceased one attempted to approach the direction of the group of farmers but was stopped by deceased 2, and he left towards the direction of Gate B. Further, that 2 vehicles of the farmers were seen driving at high speed and blocked the entrance to Gate B. That one of the farmers hit deceased one, and that is when the arguments started and shots were fired. Further, that there are statements that witnesses saw accused number 3 shoot deceased, and that some even saw one of the farmers place a firearm close to deceased one. Further, that the farmers were armed with firearms, including rifles, and wore bulletproof vests. That none of the witnesses indicated how the farmers injured at the scene sustained injuries, and that after the incident, applicants refused to hand over their firearms. Cross-examination by counsel for applicant number 1 followed, and the state witness maintained the position as per his testimony, conceding, however, to, amongst other aspects, that the applicants handed their firearms and that the version of the witnesses is one-sided. The matter was then adjourned, and on the proceedings of that day, defense counsel addressed court that it has later come to their attention that there is a video footage of what happened at the scene, whereupon the court directed that parties view the video and thereafter address court thereon where necessary. Cross-examination continued, and the state witness then conceded to, amongst other aspects, that the footage showed that it was in fact 4 people that entered the farm. They were carrying wooden sticks, not big sticks, and they entered a barn, whereafter they went out and some farm workers left their work and took or picked their belongings. In answer to a question in cross-examination, the witness said earlier, deceased one's shirt was removed while he was being approached or grabbed by the farmers, but after viewing the footage confirmed it showed him removing his shirt on his own. The witness conceded further that after watching the video, it was clear that some of what witnesses said in their statements was not true. Further, also that statements by witnesses that deceased one was stopped by occupants of the Toyota buggy was not true, as parties agree the footage shows him being stopped by deceased 2 who came with the farmers and farm workers. It also came out that the 2 deceased persons are in fact brothers. It is very sad and unfortunate that the 2 deceased persons had absolutely nothing to do with the work or job related concerns of that day. Further, counsels for the rest of the applicants cross-examined the witness, whereafter the counsel for state re-examined him. Counsel for state then closed the case. Then followed arguments. Parties addressed court requesting to provide the court with written heads of arguments and thereafter to address court further, agreeing also to cover the issue of schedules with the legal representative of applicant number 5, addressing court he is not going to provide same but will make oral arguments. Copies of the heads of arguments are attached to the record, and applicant's counsel addressed firstly, arguing that the charges do not fall within the ambit of Schedule 6, and the state arguing for the court to find that they fall within the ambit of Schedule 6. The state relying on the doctrine of common purpose. The parties in the heads of arguments and address relied on various case laws and legislation in support of their arguments. Then comes now the finding. The court starts with the heading of common purpose. On the material by Batchel, the indication is that where 2 or more people agree to commit a crime or actively associate in a joint and lawful enterprise, each will be responsible for specific criminal conduct committed by one of their number. which falls within their common design. In Snyman, it is stated that the essence of the doctrine of common purpose is that if two or more people having a common purpose to commit a crime act together in order to achieve that purpose, the conduct of each of them is imputed to the others. There must be a prior agreement expressed or implied by may be inferred from surrounding circumstances. However, the standard is that the facts constituting the surrounding circumstances from which the inferences are sought to be drawn must nevertheless be proved beyond reasonable grounds. There must be a particular or identified criminal conduct or act, as was the case with the case of Jabulani Alpheus Shabalala versus the state, the facts of which are also seemingly distinct from the facts in the present case. Also, with reference to the case of State versus Zo and another, there is an identified criminal activity, and the court said it was committed in the execution of the common purpose, since the murder had been foreseen by the appellants. It was identified. There was an identified activity. The activity was murder. It was murder of the wife of one of the appellants, or of the group of the appellants in the case of State versus Zo. The state further referred the court to the case of State versus Pretorius. But the facts in that case are so clearly distinct to the situation in the case Akwo, as they are about bail application on new facts in a matter already on trial for some time, where the applicant had admitted to court to have lied and is also said to be a flight risk. The court does not find how that find resonance with the case Akwo. The decision in the State versus Mkhondo 1989, Volume 1, SA 687, in brackets A for appellate, clarifies their position. It mentions, amongst others, the presence at the scene, and there are concessions, even from the state side, being the witness, that one or some applicants were not at the scene during the occurrence of the incident. The court has considered the evidence in its entirety, including the exhibits and documents handed into court, and also considering the fact that it would have appeared from the witness that even after he had identified before court that there were discrepancies, that the statements that he was relying on were some of them based on clearly untruths. The witness even so wanted to have to be seen to be making a justification of why things happened, which was not necessary. This was not necessary because the function or the purpose of the witness being called to court, that is not to justify anything, not to assist anything, except as to tell the court what has happened, what they have observed. Similarly to the issue of the state, the position of the state is that the state's function, it's too different from a defense counsel. There is no talk of the state winning or losing at any stage. The function of the court is, of the state to the court is one that in some decisions it is indicated that it is a special relationship. It places the state in a special relationship with the court, in that the function is to bring to court the truth, or to bring to court whatever material that they have, whether in the favor of the state, whoever, that will then assist the court in arriving at the truth. The court then, after having considered the evidence and in its entirety, the court then finds at this stage that there are no basis to find that common purpose is applicable as is envisaged in the bail legislation, being the Criminal Procedure Act 51 of 1977. Wherefore, the court finds that the charges in the case Akwo are falling within the ambit of Schedule 5.
Kantolo ke lana ke bithatha isinqumo mayelana ke nokubheka ukuthi ke ngabe ke amacala lawa abamangalelo asesigabeni ke sesithupha na, ngoba bokhona ukungavumelani phakathi ke kuba advocate wombuso kanye ke labo advocate abamele ke abamangalelo. Afushane nje okushiwo inkantolo, bamangalelo abaphambi kwenkantolo abahlanu abafake isicelo sokuthi ke badedelwe ngebail, banama meli noma ke advocate abo abamele kulesicelo ke SABC kanti futhi ke kuqhutshekwe ke kwaletha ubufakazi noma baletha ubufakazi ngokuthi banikeze inkantolo i-statement zabo ezifungelo ezichazayo ukuthi kungani bacela ukuthi inkantolo ibadedele ngebail. Inkantolo ke ithathile lezo statement yazenza ke ubufakazi kanti ke bese sekubizwa ke nomphenyi wecala warrant officer naye olethe obakho ubufakazi. Emva lokho ubese ke naye sofakwa ke imibuzo ngaba advocate abamele ke abamangalelwa bese ke sekuvezwa ke ubufakazi kafushane nje ubufakazi obukhona obulethwe ke umphenyi wecala ebufakazini bakhe. Ubufakazi ke abulethe phambi kwenkantolo ubufakazi abuthathe kuyi-statement anikezwe zona ngabufakazi kule cala. Okwenzeka ke ngalolu suku yiloko kulandelayo ngokusho ke kukamphenyi ke wecala balapha ku gate A eMpumalanga bese selapha ke ku gate A kufika umufi wokuqala ulandelwa ivein ngemuva. Uthi uma afika ukhumula ke iskipa ngokukhombisa ke kwevideo kanti ekuqaleni besinikezwe ubufakazi ngokuthi ke iskipa wasikhumula ke umufi wokuqala ngesizathu sokuthi wayelwa. Kodwa emva kokuthi kubukakele ivideo kubonakala ukuthi iskipa lesi umufi wokuqala wayikhumulela yena ngesikhathi efika egateini lo ugate A elandelwa ke ivein emhlophe. Uthi uma ngabe efika kugate A eMpumalanga waphoqa ke ukuthi ufuna ukungena ngaphakathi, kodwa ngaleso sikhathi umufi lo owesibili wayesevele ngaphakathi eplazini okubhudi kamufi wokuqala ngoba uyena omvimbayo ukuthi ke makangangeni ngaphakathi laphana ke eplazini. Kodwa waqhubekela wavukudlela wangena ke ngaphakathi ngenhloso yokuthi ke ufuna ke ukulisa ke abalimi laba bebala. Kanti ke kuvele nobufakazi ukuthi ke uhlatshwayo obizwa kuphinda phindwe ngokuthiwa ngumlaba ngaleso sikhathi wayesabanjiwe abekwe ke ku gate B. Bathi uma ngabe beqeda umufi wokuqala wasuka nala ehamba nabo nevein bayilapha ku gate B. La bathola abantu uma befika khona ku gate B bathola ukuthi ke kunezimoto ezimbili ezasivimbeke igate bangakhona ke ukuthi ke bangene ke ngaphakathi. Yila khona ke ngokusho kamphenyi wecala uma ayithola ke ubufakazi bakhe kwasuka khona ke inqoshunqosho okwaholela ukuthi ke ngeshwa bese kulahleka ke impilo zabantu ababili. Kodwa ukuthi ungabe buzwa umphenyi wecala ukuthi ke laba abalimi ke abalimala bebala balimala kanjani ayiveza ayitholakala ke impundulo asinikeza yona ayikho impendulo asinikeza yona umphenyi wecala ngoba uthi wabuza kubantu abekhona lapho endaweni esigameko ukuthi balimala kanjani. Kodwa ke kwabonakala ukuthi ke abazi ukuthi ke laba balimi labebala balimale kanjani. Kanti futhi okuvelile la uvumile umphenyi wecala ukuthi ke ezinye ze-statement anikezwe zona ngabofakazi azikhuluma iqiniso emva ukuthi sesibheke ivideo le eyabhekwa ke lana ke enkantolo. Kanti ke uma ngabe siqhubeke kube bese ummeli wombuso nabo advocate abamele abamangalelo benza izethulo emva ukuthi kuthule bonke lobufakazi. Emva kokuthi kuthule bonke lobufakazi inkantolo ke ibese ke seyifika ke kulesinqumo lesesilandelayo okumayelana nokuthi ingabe abamangalelo ngalosuku kwenza ngasisigameko babe nenhloso efanayo na noma ke inhloso eyodwa yokuthi ke benze icala. Inkantolo ekutholayo lana ithi kufuneka kube khona isivumelwano nanokuthi futhi ke kufuneka ukukhombisa ukuthi ngempela bonke abamangalelo laba babandakanye ekwenzakaleni kwalesigameko. Kodwa kunobufakazi obuvelile obuthi abanye babamangalelo baphambi kwenkantolo bafika sesenzakele babengekho ngesikhathi kwenzeka lesigameko lesi. Ngaleyo ndlela leyo ke ithi inkantolo ke ngokubheka ke amacala akhona umgedezi lapha kuphuma khona inqumo phambilini ifike esinqumeni ke esithi le cala leli elibekwe abamangalelo alikho esigabeni sesithupha kodwa sesigabeni sesihlanu. Kanti futhi ke nanokuthi ke abamangalelo ngesikhathi benza le cala noma lamacala babe nenhloso ke efanayo noma eyodwa ithi inkantolo ke lokho ke iyaqitha kusenjalo.
The court then now moves to the next point, that is the ruling. The court must indicate that the events of the day in question are so unfortunate and unnecessary that they are so unfortunate and they are also unnecessary and led to the untimely tragic loss of the precious gift that is life. Occurrences of incidents of this nature has the potential to evoke emotions, painful memories, and reminds society of the painful past where lives of certain sectors of society were seen not to matter and should then be avoided at all costs. It appears there was a lack of exercise of restraint, patience, and compassion from the parties involved from evidence so far at the court's disposal. The testimony of the state witness about cases seemingly not adequately being dealt with dating back around 8 months ago, such that communities feel they see no justice, and the existence of labor-related issues shows that there could be deep-rooted problems that go beyond this case, this bail application will not even attempt to address. It points to the vulnerability of the communities in farms. In fact, it then brings the question, is there anything civil society formations or departments can do to assist the said communities? I believe indeed there must be something. That police did not attend the scene on time, if true, it really needs to be attended to and it needs to be addressed. It must be noted that the bail application or this case is a process wherein the functions of the presiding officer are limited to the inquiry in terms of the bail legislation, and in this case under Schedule 5, whether the applicants were able to demonstrate to the court that it is in the interest of justice that they be released on bail or not. The purpose of bail is to secure the attendance of an accused person to court. It is not in dispute that the applicants are not a flight risk, that they do not have previous convictions, and no proof of existence of pending cases presented before this court. No evidence was laid that they will interfere with witnesses, commit further offenses, or that their release will be prejudicial to the maintenance of law and order and the security of the state. The state also mentioned the safety of the applicants if released on bail, which the counsel addressed court, they will be safe. On the strength of the state's case, the court is mindful of the fact that the testimony of the officer is based on statements that it later came out after viewing the video material were untruths, but still believes there is strength in the state's case against some of the appellants. However, it must be understood that the strength of the state's case on its own could not be the only consideration whether to grant bail or not, if other factors exist in favor of granting bail. In the case of State versus Lamini, it was stated that the purpose of bail is the right to freedom pending trial, with further reference to Section 35 of the Constitution, and further in State versus Eckerson 1991, Volume 2, SA 805 NM for Namibia, Judge Mohammed stated that an accused person cannot be kept in detention pending trial as a form of anticipatory punishment. The presumption of the law is that of innocence until guilt is established in court. The courts will ordinarily grant bail to an accused person unless there is likely or unless this is likely to prejudice the ends of justice.
Kantolo ke ikhuluma ke ngesicelo se-bail sabamangalelo la inkantolo ithi khona lokho kwenzeka ngalo suku lolo kwaba nje yishwa futhi kwakungenasidingo sokuthi ke kungenzeka ngoba kwagcina ke kuholela ukuthi imphefumulo kulahleke imphefumulo emibili. Kanti futhi lokhu kukhombise ukuthi ke amacala afana nalawa ngamacala asibisele emuva akukhumbuza ke izinto ezenzeka ke emuva. Kanti futhi ke aphinde futhi ke ukukhombisa ukuthi lesigameko lesi esenzeka womabili zombili inhlanga lezi azange zakhombisa ukubekezelelana. Kwakungekho ukubekezelelana kwabakhona ngalelo okwaholela ukuthi ekugcineni kulahleke ke imphefumulo. Kunamanye amacala esike sezwa kukhulunywa ngawo kuthiwa ke asenezinyanga ezingu-8. Lawo macala lawo kubonakala ngathi akwenziwa ubulungiso kulawo macala. Wesibili kuyavela futhi ukuthi namaphoyisa ngesikhathi ebizwa awafikanga ngesikhathi. Zonke ke lawo namaphuzu lawo amabili yinto leyo engalungiswa. Okumele ukuthi ke amaphoyisa athathe ke inyathelo noma azame ngawo amandla onke ukuthi ke athathe ke inyathelo mayelana ke nalokho. Kanti ke njengoba bekuyachaza phambilini inkantolo ukuthi ke umphenyi wecala uvumile ukuthi ke emva ukuthi asabheke ivideo kunezinye istatement zabofakazi ezingakhulumi iqiniso mayelana ke nesigameko ngokwazi ukuthi ke ngabe kwenzakalani ngalelo suku. Okunye futhi okuyaye kubhekwe uma ngabe kufakwa isicelo sebheli ukuthi ngabe abamangalelwa kungabantu abangabaleka nabangabuye enkantolo bangaphazamisa mhlawumbe ke ukuthi kwenziwe ke uphenyo ukuphepha kwabofakazi. Ithi inkantolo uma ngabe ibheka wonke lawo maphuzu lawo abamangalelwa yakusibona abantu ngathiwa ke bangabaleka bangabuye enkantolo. Kanti ke angeke futhi baphazamise uphenyo noma ke bazame ke ukuthi ke baphazamise abofakazi kule cala. Ngaleyo ndlela leyo ke ibail akusiyona eyokuthi ke kumele kujeziswe umuntu. Ibail ilabonakala khona ukuthi umuntu uma ngabe lethe ubufakazi zikhona na izizathu ezimqoka nezibalekile noma ezingajwayelekanga ezigenza ukuthi inkantolo lo muntu imnikeze ibail noma kanye kwenziwe ubulungiso uma ngabe ededelwa ngebail. Ngaleyo ndlela ke inkantolo ke ekutholayo la ukuthi ke uma ngabe ke lezo zizathu lezo zikhona inkantolo ke inelungelo lokuthi ke labo bantu labo abafuna bafuna isicelo sebheli ngaso isikhathi ibanikeze ke ibail.
Wherefore, the court rules that the applicants have been able to discharge of their honors to demonstrate to the court that it is in the interest of justice that they be released on bail, that their bail application is successful, and therefore bail is granted.
Ngaleyo ndlela ke inkantolo itholile ukuthi abamangalelwa bakhonile ukuveza ukuthi zikhona izathu ezimqoka nezibalekile kule cala. Ngaleyo ndlela ke inkantolo ke abamangalelwa iyabanikeza ke ibail.
The court now then gives the opportunity to counsel to address on the bail amount. The court has ruled on the bail. The court now wants counsel to address.
The last indications of an amount, maybe it would be true. Would your worship mind if I approach my learned colleague on behalf of the state? Maybe we can reach agreement, then we don't have to waste your time with argument. I don't think it's necessary to adjourn. If I can just be allowed to approach my learned colleague, maybe for a few seconds, in order to find out what his suggestion is. We may and will probably agree with his suggestion, and then it's not even necessary to formally address you on the issue of bail conditions in the amount, etc.
You may approach counsel.
My learned colleague says he's not got any real objections. I think in the view of the fact that the accused are not at flight risk. There are suggestions of 10,000 rand under the circumstances, although it is very serious crimes that we're talking about. But in view of the fact that there's formally on record that there's no flight risk, and in view of the fact that the state then doesn't oppose it, I will again submit to your worship that an amount of 10,000 rand for all the accused, apart maybe from accused number 5. Can I just take approach from my learned colleague on behalf of the people? Although accused 5 is obviously in a different category, we have no objection, and I have now the authority from my learned colleague on behalf of accused to submit that even in this instance we will be satisfied, subject to your worship's discretion, that all 5 accused are ordered to pay 10,000 rand bail. As far as further conditions, it doesn't seem to me that the state insists on any further conditions. We submit that in view of the fact that there are no flight risks, there need not be any further conditions apart maybe from the general conditions that courts usually give, that there should be no interference with any of the state witnesses and or evidential material. In that regard, we would just then request your worship to direct the state to, as soon as possible, provide us a list of state witnesses in order to absolutely ensure that there will be no contact and or interference with state witnesses.
Thank you. And counsel, in confirmation for accused second applicant, you confirming the address? Thank you. And counsel?
We confirm.
Counsel? Thank you. Counsel for the state, may you address the court on this aspect?
Worship, it puts me in a very difficult situation to can inform you which witnesses give the restrictions. The farmers are working, the state witnesses, your worship, the witnesses are working for the farmers. If I say there is a particular person not to speak, they earn a salary from the farmers.
You will not be in the position.
I won't be in a position and say they must not be in contact with this one or that one or what. As I said earlier on, that the witnesses work. Some of the witnesses are working for the farmers.
In short, counsel, are you saying that condition will then be unworkable?
It's not going to be unworkable, Your Worship.
Thank you.
In that case, that's what the state have said. There's interference. But anyway, I'm not against the ruling of the court.
Yes.
To the fact that there wouldn't be an interference. The state said there will be interference. But I'll check it with my superiors.
You really have to take whatever you have with you are very free to do that. That is how it should work.
I don't have any.
And on the request, the court indicated it wants an amount. Now that it has ruled, then all it needed is an amount. And any amount or no address in that aspect?
Also any address to the amount, whichever amount I can say, the accused will still be in a position.
They will still be in a position to pay.
Still fight.
Thank you.
We should, just in the interest of justice, maybe what you can order, although the state says it's not workable, that you then make an order relating to specific state witnesses, in order to protect people and potential witnesses. Maybe I can suggest, I have no instructions to talk on behalf of the other accused, but maybe it will be then in the interest of justice that you make an order, at least to the extent that you order the accused not to discuss this case with any of the farm workers, pending then at least till we have the docket to see which people are state witnesses, and then we can consult with other people. But at least pending that situation, that the accused may not discuss the case with any of the farm workers, I would submit that would at least then protect them to some extent, as you please.
Thank you.
Boboniswana ke la ukuthi ke ingaba imalini abamangalelwa imali abangayikhokha okuyimali ke.
We've lost connection there, but there you have it. The 5 accused getting bail. The family, the Coka family, saying earlier that they were against the provision of bail to Orchard Klimberg, Danny Malan, Cornelius Greiling, Ignatius Steinbeck and Zenzele Yende, who are accused of killing the brothers Zenzele Coka and Mkini Coka on the 9th of April in an altercation between people who were supposedly looking for work and the farmers. But there's the outcome. Bail has been granted. We will get more on the story from our colleague Dumelo in a bit.